welcome everybody to our bi-weekly webinar. I'm Ryan Poole. I'm a co-host with Jim Brown. I'm a real estate agent, just like you all. Been doing this for over 20 years. Love the industry. We got some big changes that have happened here in the last few months here for NAR and in the settlement agreement. And the awesome thing is that we have a great real estate attorney here, Jim Brown, founder of New Path Title, the awesome closing software Title Leap. That's going to bring some clarity to the issues. So really excited for this week's bi-weekly webinar. And as Jim said, one of his favorite sayings, iron sharpens iron. We're all going to learn from each other on this, right? We're all agents. This is all new. This is all heavy duty stuff that we're having to deal with in our industry with all these new forms and how we're going to get paid and all these things. So we're all working really hard. So go ahead, Jim. Why don't you go ahead and take over here?
Yeah, my name's Jim Brown. I've been working in real estate for 40 years, private practice for 20, and closing transactions for you guys all over the state of Florida. The goal for today is for me to get you information you won't hear anyplace else. What I was telling Ryan as we were logging in, there's a ton of misinformation out there. We'll go over it more in depth. Your association is protecting their position. Your national association is protecting their position. Your boards are protecting their position. I feel comfortable going out on a limb, giving you guys opinions. You're not my clients. It's dangerous to always give opinions because anybody you give an opinion to becomes my client by default as a lawyer. But I'm happy to, and I feel that we're better as a industry if somebody takes some risks and gives and calls it the way they see it without qualification. And that's what my goal is for you. There are no dumb questions. So anything you guys have for a question, throw it in the chat, depending on how many people we have. We'll go over it agile as we're going and how relevant the question is. Otherwise, we'll go over it at the end. I'd love to keep this to 45 minutes, but there's so much here, it might turn into an hour. If you turn on your camera, I know it might not be comfortable all the time, but it's great because I can see your reactions. It makes it a little bit better show. Again, we'll have question and answers at the end. Ryan's going to give you some time-saving tools that I completely endorse, and I think they're wonderful. You can text me 24/7 with any questions you have, and we're going to introduce to you a little series we're going to do in the form of reels we're calling Behind the Closing. So every week, Tajay and I get the benefit of seeing, and Christian, we get the benefit of seeing what's going on in the real estate world from a practical boots on the ground perspective. And we're just going to make a series of really short videos saying what we saw that seemed to stand out in the week. And for the last couple of weeks, it's been creative finance. And we'll go more into that in the Behind the Closing series. Today, we're talking about a whole plethora, I'm not a big fan of that word, a whole plethora of topics. So I'm going to share my screen. You guys don't have to take notes. You'll get a copy of this after the show for anybody who wants it. And Ryan, you can see my screen?
Yep, can see it, Jim.
All right. So what are we talking about today? We're talking about maximizing realtor productivity, 3 flavors of the buyer's agency agreements, how I'd work the new listing agreement, how I'd make offers, demystifying 3C of the new listing agreement, more NAR rule changes are likely coming, but we can take action today, and Tales from the Street. I want to bring in Tajay and Christian and talk about stuff we've seen and the whole host of misconceptions that I continually get texted on. Not a problem. If you guys want to text me anytime, just give me a little fact pattern. It helps when we talk to know what's going on. Just text me a little fact pattern. I'm happy to go over anything you guys want to go over 24/7 to help you get to the closing table. All right, the date is August 26, 2024. The proposed rule changes went into effect August 17th. The final rules are a couple of months out. These are not final rules. These are preliminary rules that the industry has adopted. In the meantime, the rules, playing field, and opinions of brokerages and their attorneys are changing daily. Honestly, just like me, I'm seeing the new listing agreement in a whole new way after listening to EXP and real attorneys. So agents are best advised to keep their ear to the ground and their eyes open and stay receptive ready to pivot on what you thought was solid ground. It's just the way it's going to be for a little while. And if you have that mindset, you're going to do fine. I'm not a hollow cheerleader. I'm not going to tell you, like you see in so many videos, rah, 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 this is a tremendous opportunity. This isn't. This is painful. This is difficult. The rules aren't real clear. But I think after our discussion today, I'll give you some solid ground everybody can operate on and lean into and create some predictability for yourself. Again, I'm still getting calls every day. The transactions not governed by SITs or NAR settlement are vacant land, leases, commercial properties, and transactions for 5 or more residential units. So those aren't what we're talking about today. We're talking about everything else but more and more tenants, agents are using the showing agreement to ensure their lease commissions, and we'll discuss more of this below. So I've seen several tenant agents representing, realtors representing tenants using the showing agreement. All right, first I want to talk about the pre-touring, showing, and buyer brokerage agreements. There are 3 flavors of the agreements the Florida Realtors has provided. All the new forms are dated 7/24 at the bottom of the page. Each represents a varying degree of involvement with the buyer. They all have the shameful disclaimer at the bottom of the form. We'll go over that in a minute. I'm not going to review the forms line by line. There's great Florida videos. I gave you links to this. All I'm going to do is compare the weaknesses and strengths and merits of each of the forms. So the property pre-touring agreement. Does everybody know what I'm talking about when I say the property pre-touring agreement?
Yep.
All right, so this is a select form. This is the short 1-page form with just a couple of paragraphs. Florida Realtors calls this a flirting agreement, says supposed to be a day or so. An agent could show a buyer a bunch of properties and never get paid. That's the problem. Even with this agreement signed. The reason why in the agreement itself, it says, if you wish to work with the broker. So many agents believe that they're protected because they got this property pre-touring agreement signed. It says, if you wish to work with the broker. Can you see that, Ryan, or is it
Yeah,
too
I can
small?
see it. Yeah, maybe just highlight it so people can see that. Yeah, there you go.
It says, if you wish to work with the broker. So they show you a bunch of properties and you say, I don't wish to work with the broker. Guess who's not getting paid? Just saying.
Yep. So
Uh,
basically, yeah, I mean, like you said, this is kind of like the flirting stage, right? Where you're going into the first time speaking with a buyer and they're saying, hey, you could get this signed. And there's basically, an agreement that you can get paid if you work, if you wish,
if you wish.
if you wish. Geez, that's some bad verbiage.
Ryan, is it better if I put these forms side by side with the outline like we did last week, or do you like bouncing back and forth?
I mean, great if you could put them side by side, which would be nice.
Yeah, I think I can do
It's
that.
not too difficult.
No,
There we go. Perfect.
sorry, you guys.
Yep, we got it.
Honestly, I was up all night finishing this thing until the wee hours of this morning. And we're doing this agile, just like you guys have to do this for your clients.
Mhm.
It's just the nature of change. You don't want to fight the change. You want to go with the change and you want to figure out knowledge is power. All right. Can you read the touring agreement, Ryan?
Yep. Yeah, no, it's clear. It's clear, Jim.
Everything's clear? All right. If you wish to work with the broker is the thing that hurts us. And so that's not objective, that's subjective. And so by virtue of that statement, if they don't wish to work with you, guess what? They do not have to work with you. Let's see, seller's financing, seller's attorney, we want listing disclosures, property touring agreement. Sorry, you guys, forms, listing, property pre-touring. This is the sentence right here. Again, if you wish to work with the broker to purchase the property, they may ask you to sign an agreement. That's the statement that hurts you. Does not form a general agency. So this is only on property the broker shows you. So because this doesn't form a general agency, this is just property specific. No extension period if a contract is signed, like in the showing and the BBA. The BBA is the buyer's broker agreement. So this thing has a finite period. If you don't sign something during the period, too bad, so sad. Again, you're out of commission. Not a big fan. I hear a ton of Florida realtor, and I hear a bunch of brokers saying they want to use this form more. I would say use this form less. Showing agreement. I am more of a fan of the showing agreement. I think the showing agreement does a good job. You see it on there, Ryan?
I'm looking. This exclusive buyer brokerage agreement, single transaction broker, that's the one we want to use. Yeah, right there.
No, showing agreement is one, there it is right there. They call it FAR showing agreement.
All right.
So the showing agreement is what they call a dating agreement. It's supposed to be for a week or so, but I see some agents closing on their files on these agreements. So they're using these things in lieu of a BBA. The second paragraph must be property specific. That's pretty obvious. Paragraph 4, this is where I really start to like this agreement a lot. Buyer must tell broker when they want to buy. So there's a specific duty in the agreement that says that the buyer has to tell the broker when they want to buy. Buyer must tell other agents when they have a broker. Indemnifies broker for buyer misrepresentations and requires buyer hire proper consultants. Like there's a whole lot of great protections in here for agents. Calls put a default if buyer is not acting in faith. Let's see, calls a buyer. I'll go over this more closely before I circulate. Default if buyer is not acting in good faith. It says right there, if the buyer is wasting your time, that's a buyer default. Well, if there's a buyer default, guess who might be entitled to a commission? I like it. Compensation. Here's the biggie. Commission is earned when the contract is signed. So if buyer cancels during inspections, loan approvals, condominium association disclosure failures, or even second deposits fail to get placed, the agent has earned their commission.
What?
Full stop, full pause, game changer. I can't stress enough. This is going to change in and of itself the landscape of real estate, and nobody is talking about it. I have not heard one Florida Association discussion. I haven't read anything, but think about it. If you
Can you
have
scroll down to 5, Jim, so we can read that on the showing agreement here?
broker's commission is earned when during the term of this agreement or any renewal or extension, consumer or any person acting on behalf of consumer, an attorney, a power of attorney, contracts to acquire real property as specified in this agreement. Contracts.
Wow.
They sign the contract. Now, I'm not suggesting for a second that you start suing buyers for your commissions if they cancel during the inspection period and you're a buyer's agent. But I am going to tell you, under the forms, you have a right to that commission if they cancel during the inspection period. I don't know if this wasn't fully contemplated by the draftsman at Florida Realtors. I don't know if there are unintended consequences by what they drafted. I don't know if there's going to be more provisions added qualifying that commissions would be cut off if the buyer volunteer. But here's a conflict, and I'm just going to tell you right now, this is a barn door that you could drive a truck through that at some point we have to start to close up, but this is a huge issue, opportunity, liability, exposure, just something not contemplated. And I haven't heard this from anybody else, but this is just doing my research and reading this thing 1,000 times. These are the conclusions I've come up with. It has an extension period built in, unlike the showing agreement. Unlike the pre-property touring agreement, the showing agreement has an extension built in. Or any extension thereof during the term of this agreement or any renewal or extension. Can you see my cursor? That's the automatic extension. So if you sign it and you don't close until a month after the termination of this agreement, then you'd still be entitled to your commission. Has a leasing provision. Theoretically, an agent could strike A and use it for leasing only. Many agents call about leasing contracts. So this thing has a leasing provision built in, the showing agreement. If you use it to go out and show, if you represent tenants to go out and show, I'm seeing agents doing that. A little, I won't say trick or hack, it's just something we see agents doing. Can be modified by agreement. So as things change, you can have additional agreements, addendums to this agreement. These aren't etched in stone. You do not need to show this to the seller's agent on demand. We'll go more into this later. And there's a ton of misconceptions about the whole disclosure of these things, but we'll go into more of that later in the show. Buyer can have several showing agreements with multiple agents. These are property, not agent specific. Is that clear?
Yeah, that's what I was going to ask. So this is property specific for one specific property. The showing
One or more.
one or
I mean,
more.
you can, in
Can you
theory,
scroll up and see? I want to see where it says that up at the top, where it lists out what it says here. Consumer.
number 2.
Okay. Okay. Wow. So you could list multiple properties on there.
So if you wanted to, you could attach an exhibit. You know, you could even write in here, see attached exhibit, and you could have 100 properties in your exhibit.
Well, let me ask you this question, because I kind of like this agreement. Could you, as you show properties, just write in the MLS number, have the buyer initial for each single one?
100%.
Yeah, so that could be an easy.
I mean, it's agile, right? And
Yeah.
agile is what we all want. We all want low hurdles, low bars to entry.
Okay.
Here's the Florida Realtors line by line explainer of the form. I don't want to go into it. They do a pretty good job. Next, I want to go into the buyer's brokerage agreement. They're also calling this the BBA.
So they call this the marriage agreement.
They call this the marriage agreement.
Yeah.
So compensation agreement, exclusive buyer broker. So here's the one you want to use, the transaction brokerage form. We'll go over how you identify it as the transaction brokerage form. They call this the marriage agreement. It's designed in from what they're saying for any duration of time, typically 6 months. There is no reason why you can't use a showing agreement for 6 months. But when you listen to the Florida Association of Realtors, they talk about this being a longer term form. I see, wow, a lot of people still pouring in. I see the transaction broker form used most often. Look in paragraph 12. So if you scroll down to paragraph 12.
Yeah, because it gets confusing on this, guys. This is where you want to really see right here. It's on paragraph 12.
If you look on paragraph 12, it says the brokerage relationship. Broker will act as a transaction broker. The other ones talk about transitionary brokerage, single agent brokerage, no duty brokerage, all that stuff. I've never seen anybody in Florida use anything but the transactions form, but I am 100% receptive as to why somebody would use another form. I'd love to hear the explanation. Term, like the showing agreement, it's flexible. This agreement automatically extends if a contract is signed during the term of the agreement. Does everybody understand what I mean by that? So if the contract gets signed, if the purchase and sale gets signed during the term of this agreement, you don't have to make an extension for the agreement. I get a text from agents a couple times a week now. They want to know if they have to extend the agreement because the contract doesn't close for 5 or 6 months, which you see. We do get closings periodically that are way out in the distance. No, you don't is the answer. Unlike the showing agreement, In the exclusive BBA, the broker is the exclusive agent of the buyer. That's the big benefit here. Good to ask when signing one with the buyer, have you signed one of these with another agent? So if you're signing a showing agreement, I don't want to add confusion. My goal is to add clarity. But if you're signing a showing agreement, that buyer can have signed multiple showing agreements with other agents. There's no conflict there. However, if you want to make sure you're the one getting paid, you use the BBA and you ask during the course of conduct, when you're filling out the BBA, have you signed one of these with anybody else? Now, your buyer is not going to know the difference between a BBA and a showing agreement or a pre-touring agreement, but at least it forces the conversation to identify what they may have signed prior to sitting with you. And then you can decide how you want to work with that buyer, or if you want to work with that buyer. The property in paragraph 3, general. It's not property specific.
Yep. And what are they saying on location wise? I mean, are people putting in the whole state of Florida?
People are putting in the whole state of Florida. The best brokers that I've heard advising their agents on this say, use the geographic location that you're expert in.
Yeah.
Unless you're working with an investor and they want you to work with them all over the state, and you're going to find sub agencies and things like that. Pretty much the brokerages that I lean into to hear what practical ways of working and information they're giving their agents in the street. They're saying just give the location that you're most confident in, you're expert in.
Hey, Wendy had a quick question. Would you recommend adding in additional terms of the exclusive buyer broker agreement that buyer has not signed another BBA with another agent? Would you recommend?
That's already in here.
It's in there?
Yeah.
Okay.
Good question. And it's in there. Consumers' obligations. Refer all agents to seller or anyone who contacts buyer about purchasing a home to broker. Big, huge bonus. That is an affirmative duty right there. Do I like this form? I don't like this form. Are there parts to the form that I really like? Yes. Could they have added this to the showing agreement, or could they have put more protective language in the showing agreement? Yeah. Could they make this form shorter? Yeah. But I really like this provision. Tell anyone trying to sell buyer a home they have a buyer's agent. Bam! Like it. It's all there. This is under consumers' obligations. This is under A. Conduct all negotiations ever locate a sample properly only through broker, capital B. That is you. I heard brokerages telling their agents that the brokers have to sign this form because it's capital B. No, capital B is a defined term. Capital B is defined as the agent executing the form. Could you imagine if you had to go back to your broker every time to get this thing signed? This is the broker is defined as the agent working with that buyer. Lowercase b, although it's very confusing, is every other broker in the transaction, aka seller's agent or any sub-agencies or things like that. Capital B refers to the you if you're the one working this agreement with a buyer. Is that clear?
Yep.
Pay attention to the capitalization, it matters. Meet with broker at reasonable hours. Boom!
I like that
No more
one.
calling your agent in the middle of the night. I got to see this property before I go to work, and my shift starts at 5. True story. I have clients calling agents telling them that. They don't have, now you don't have to do it. It's in the agreement. Identify broker is pretty broad, but I love it. So there's a blanket indemnity provision in there. D, identify and hold broker harmless from and against all losses, damages, costs, expenses of any kind, including attorney's fees from liability from any person. Love it. Do I think it's generally enforceable on all situations? No, but I love the fact it's in there. Go ahead, Federico.
Quick question, just curious. Have you seen, what is your experience? Have you seen brokers demanding buyers or sellers demanding their clients?
Demanding.
Yeah, suing.
I have not seen brokers suing anybody. I have seen, and we'll go into it in a little bit, penalties being levied against agents, none in Florida. But we'll go into depth about who I think agents need to be leery of. Compensation, like the showing form, the buyer's agent fee is earned when the contract is signed. So paragraph 7, huge for you guys. Broker's compensation is earned when during the term of this agreement or any renewal or any extension, consumer or any person acting on behalf or through consumer contracts to acquire real property as specified in the agreement or defaults. So again,
Jeez.
so if buyer cancels during the inspections, I'm so glad you're like revolutionized by this, Ryan, because the reality is I'm reading this thing in isolation. I haven't heard anybody talking about it.
I know.
The fact that it's resonating, I mean, this is powerful stuff, but this is subtle, right? And you don't think about it at first blush. This is why I'm telling you guys to be critical thinkers.
I just wonder what, I mean, the public perception of this, if this gets,
Nobody in
I
the
mean, people are, they're going to say, hey, buyer, yeah, if you sign these new buyer broker agreements and you cancel the, the property, you could still be on the hook to pay your buyer's agent. I mean, how does that make us look?
nobody on the consumer side has figured this out from what I've seen in the media.
I know. Wow.
And even if let's just say you're working with a buyer and they don't put the second deposit up, they put the first deposit, they sign the contract, they put the first deposit up and they don't put the second deposit up, guess who's entitled to a commission? In very few situations would I ever pursue a buyer for a commission if I was an agent. But let's just say you're working with a hard-fought buyer and they don't put up the second deposit, that's a bad faith buyer. Would I go after your commission there? There's not much chance you're going to work with them in the future. I mean, you got to weigh it out, right? Your goal is to get a commission, not file lawsuits or make demands. But at the same time, that's pretty bold, I would say. And I've seen some agents use this as a leasing compensation form in the same way we talked about the showing provision, the showing agreement. Protection period, number 8.
This is important. Yeah.
So strike this last sentence. You're entitled to your compensation if the agreement is struck and a contract is signed during the term of the provision, during the term of the agreement. However, consumer's obligation to pay broker's fee ceases upon consumer entering into a good faith exclusive buyer brokerage agreement with another buyer broker after the termination date. So they call you on Monday, and this is a true story. They say, my family's sick. We got to terminate this thing. We can't buy or sell, whatever their excuse is. Tuesday, they sign up with another agent. Let's just say it's their cousin or the guy they work out with at the gym, and they sign a brokerage agreement for 0 commission, and they end up buying a property you showed them. They don't owe you a commission. Now, you can make an argument that it's a bad faith transaction. Ceases upon entering into a good faith exclusive buyer brokerage agreement. That word good faith would preclude the binding nature of the agreement they made to cut you off. However, that's an argument. Who wants to have to argue for their commission? You don't want to be arguing good faith or bad faith. You just want to say, hey, you terminated my agreement Monday, you bought the property Tuesday, Wednesday you owe me a commission. Does everybody follow me on that? So just strike that last sentence. How I'd work the new listing agreements. Again, you guys, I'm going out on a limb telling you this, but I have confidence that what I'm telling you is the best advice that's available today. 10A or 10B dilemma. I get a ton of calls. I get tons of calls on this. There is a perfect example of Florida Realtors giving you guys, this is a perfect example of Florida Realtors giving you guys options because they don't know, they don't want, know, or are afraid to take a stand. If you listen to the brokers talk about, does everybody know what I'm talking about?
Yes.
Listing agency, transaction broker.
So now we're moving to the new listing agreements.
This is the new listing agreement. You can identify it because it says 7/20/24 on the bottom. The exact provision I'm talking about. is this election where we're talking about seller authorizing broker to offer compensation to buyer's broker? Again, capital B and small case b. Can you guys see the cursor?
Yep.
Capital B and small case b, and then seller paying the buyer's agent themselves. That's the difference between 10A and 10B. So Compass is a 10A policy shop, and EXP and Real are 10B policy shops, and they're openly advertising this, coaching their clients and things like that. Why? When I first read the new listing form dated 7/24 at the bottom, it was my opinion agents elect 10A and split the commission with the buy side, and had no idea why they would make even a 10B provision. It just seemed overly complicated to me. 10A looked familiar, looked like the old way we did business, and provided the easiest opportunity for a double dip if there was no buyer's agent. So I was telling everybody to use 10A. I don't want to add confusion to the dynamic. However, after listening to several legal perspectives, including lawyers for EXP and Real, who only allowed 10B election, it's now my opinion that agents' best opportunity for ease of explanation and to avoid future liability is to use 10B.
And
Why?
can you expand on that?
What's that?
Yeah, expand on that, Jim.
Simply because 10B makes the commission payment structure between the parties, takes the selling agent out of the role of paying buyer's agents and has buyer's agents paid directly by sellers or buyers. So there can be no air of agent impropriety. This is an agreement between a seller and a buy side. The agent's not even in the middle of the payment scheme. So in my opinion, it cuts off those potential claims in the future that sellers agents did something wrong. If selling agents are not paying buyer agents, it would be tough to sue them later for some perceived impropriety. Future lawsuits are my fear. So I say take the selling agent out of the role of paying buyer agents. If anybody, that doesn't make sense to anybody, I'm happy to linger on that. That's a huge issue that I can see, and I'll go in a little bit into depth as to why I see that's a possibility. Now here's how you implement it. If agents use 10B, here are my thoughts on how to structure deals and leave open the opportunity to get paid on both sides when there are no buyer's agents. How do we bold that out? In 8A, put a big shareable commission. I'm not supposed to say numbers. You hear a bunch of Florida Realtor Association people using bananas or apples instead of commissions. You know, let them sue me. I say you put a big number in 8A, it's going to be a 6. Elect 10B. So come down here, elect 10B, and then you put your commission to split down there, and then so that's the piece that the seller is going to pay directly to the buy side. So in 8A, you put the overall commission piece. In 10B, you put the piece that seller is going to pay the buy side. Seller authorizes broker to offer compensation to buyer's broker from seller in the amount of the written agreement between seller and buyer's broker. That's the piece that's going to get paid by the seller to the buyer's agent. The selling agent is completely out of the dynamic. And then in the additional terms,
yes,
you would write broker's compensation shall be reduced by the amount seller pays buyer's broker. However, the compensation due broker shall not be less than 3%, or whatever number that you guys elect. So now let's run through the scenarios. And this is the chance where everybody can chime in, because this is the value of a group. You have a 6 at the top. You authorize a 3 to be paid to the buy side by the seller, not the seller's agent, and there is no buy side agent. Where's the 6 going to go? It's gonna stay with the broker, capital B, you, the person who signed the listing agreement with the seller. Does that make sense?
Yep.
I'm going out on a limb here, you guys. Don't leave me naked. Back me up.
So if you do the 6 at the top, and then the seller's offering the buyer's broker 3%, just in the additional terms, broker's compensation shall be reduced by the amount seller pays buyer's broker. However, the
So if it's a
compensation due
6 at the top and they pay a
Yep.
4, or they pay a 2, or they pay a 1, that's what's going to be reduced from the 6. It's easy to explain to your seller. It makes you not arguing or fighting for additional commission should dynamics change in the transaction. You might get a buyer that only wants a 1, a buyer's agent that only wants a 1, and your seller's paying a 6.
Here, Federico has a question.
Yeah. Do you expect anybody to use 10C?
I have heard from many people that agents, I heard from an agent, was tonight, Monday night, Sunday night, that their seller only wants C. And we'll go into how to handle that in a minute, how to make, in the next section, how I'd make offers. Before you use this, get your broker's authorization. A lot of you guys are boutique brokerages. You're your own broker. I have no problem working with you one-on-one and talking this through with you further. Be prepared to be agile. I'm receiving lots of texts from agents telling me sellers are choosing 10C. Oh my God, Federico, how funny is that? If sellers elect 10C, a buyer's agent calls and asks if the seller is paying buyer's comp, just tell them, include it in your offer. We'll go more into that in a second. Does anybody have any questions on this section of the sellers of the new listing agreement?
No, I mean, it's Wendy has a question.
Lay it on us.
Okay, so you know those additional forms where when you have an offer come through where it says the seller is going to compensate the agent directly.
Yep.
If you have A marked,
We'll go over
Do
that
you-
in a second. Yeah, you got the right idea. If you're using A, you're going to use the form that says seller's agent to buyer agent. If you're got B elected, you're going to use the form seller directly to buyer's agent. But I'll go over a way to manage that. I think that cuts off, that's a whole lot of conversation. It's a whole lot of options. And I think that's a really good example of the Florida Association of Realtors giving you guys too many options to protect themselves. All right, how I'd make offers, buy-side strategy. Make that offer, include buyer's compensation in the offer if that's what buyer wants, regardless of whether buyer's concessions are offered in the listing. Again, full stop, full pause, let that resonate, percolate, whatever you got to let it do. This is not just Florida input I'm giving you guys. This is input from 17 states that have been using buyers agreements forever and have had some version of our rules in place for a lot longer than we've been facing. Make offers that make that offer, include buyer's compensation in the offer if that's what buyer wants, regardless of whether buyer's concessions are offered in the listing. My opinion on how to make offers, whether or not the listing shows seller is paying buyer's comp. In paragraph 20 of the contract, right? Tajay showed me this a couple weeks ago and I've been seeing it more and more. This contract is contingent on seller's side paying buyer's agent 3% at closing. It does not say seller. It does not say seller's agent. It says seller's side. This is my perspective. I haven't seen anybody say this in any other forum, written anywhere, said anywhere. But if you say seller's side, who is that? Could be the seller, could be the seller's agent. It's a blanket statement. I think Wendy and I even talked about this in in my lobby a couple weeks or a week ago. Or whatever commission number your buyer wants. Have your buyer sign the offer. Very critical. Have that offer signed by your buyer. Why? Because that is the buyer's directive. That is not your opinion. Agents are conduits for their clients. Agents are not independent thinkers of their client's position and independent advocates of their client's position. Agents are conduits of what the buyer wants to achieve in the transaction. They do not have an independent opinion. Whenever you broadcast something to the other side, and I saw an agent run afoul of this the other day, don't be broadcasting your position. Be broadcasting your client's position. What does that look like? You're forwarding an email from your client. You're forwarding an addendum from your client. You're not forwarding your client's position. Tajay is familiar with this transaction. They were arguing over post-closing furniture and things like that. And the buyers and the seller's agent said something that the seller didn't authorize. And now the seller is being attempted to be obligated to buyer's agent attorney's fees. If your client didn't say it, don't advertise it. And I don't want to belabor that too much, but I also want that to really sink in. Some agents that I've been educating for years recite this to me years after I told it to them, and it always makes me happy. Have your buyer sign the offer. Why? Because now that is your buyer's position. And we'll go into why you don't make phone calls ahead of the offer about compensation. Send the offer to the seller's agent. With the offer, send the seller to buyer's agent compensation agreement with the same percentage as the contract offer. So in your contract, you said seller's side, not seller's agent, not seller. Seller's side is going to pay this commission. In your compensation agreement, you're sending one form. It's the seller to buyer's agent compensation agreement, and it's got the number in the contract. And your buyer already said, because you got them to sign the contract, this contract is contingent on seller side paying buyer's agent at closing 3%. Is everybody with me? Does that make sense? Now you've streamlined your offer. You've left one form on the table. You've given them one option. Let them come back and say that the agent is paying the commission. And you've streamlined your efficiency. But it's in the contract that the seller has to pay this or there is no offer. The fact that you have had the buyer sign the contract with the buyer's compensation provisions, that should be plural or that should be possessive. In it before the seller side sees it, helps to insulate the buyer's agent position from potential future liability. I want you guys to operate in a way today that you're not getting in trouble tomorrow. And I think this is a clear path when the transaction is occurring on the compensation to buyer's side between sellers and buyer's agents directly that keep you out of trouble, that keep you out of potential future trouble. I want to underline this because I think this is so critical. The more and more I listen to pundits talk about this, the more and more it's clear to me that this is a problem. We had some discussions early on in this forum about just this topic, right? You guys have a duty. Your principal duty as an agent for a buyer is to make a transaction happen. If you put your interest in front of your buyer, you have corrupted your duty. What do I mean by that? If you're calling sellers and saying, hey, are you offering compensation? And that's in anywhere part of the dialogue, that gives the perception of an impropriety. Because what might you do if they say no? If you're ever on the stand, God forbid, and you have to testify, why did you call? What are you going to say? Because if they weren't offering compensation, we weren't going to offer. Bad answer. What you want to say is, we made offers on every single property, regardless of whether they were offering commissions or not, concessions or not. So I would not call it, and I heard the attorney for EXP explain this really well yesterday. I would not call listing agents pre-offer if your only question is the seller offering buyer's comp? This may be perceived as an agent impropriety, the agent putting their needs ahead of the client's. I don't see how it could be perceived any other way. I'm just saying. It's one thing if you surf a website, but if you make the phone calls and you ask, I think that's problematic. Does everybody know what I mean by that? If the MLS doesn't say seller's concessions to buyer, and let's just say the EXP website has the property on there and it has some reference to a concession from seller to buyer, I don't think that's problematic for an agent to act on that or research that, but I think it could be problematic if buyer's agents are calling sellers agents and saying, hey, are you offering comp? I've heard a million discussions saying to do it. I've seen a million discussions saying to text it. I'm suggesting to you, you don't, and you just make your offers and you put it in the agreement. Anybody have any questions on that?
Very powerful, Jim.
I'm breaking a sweat. I'm nervous.
I know. I mean, it's very powerful. You know, I mean,
you guys, right? It's a hard stretch to get to think that an agent paying another agent could be problematic. In my mind, that's a stretch, but it's no stretch to me to think that liability doesn't arise if sellers pay buyer's agents directly. That's an easy bridge to cross in my mind. That's how I want you guys to think. And I've come full circle on this, but it's taken hours and it's literally days, 2 weeks of the last 2 weeks of listening to this stuff 24/7. All right. Does anybody mind if we move on? We got a couple more topics to cover and we're at 10:48. Demystifying 3C of the new listing agreement. I don't want to belabor the point. This is the most misconstrued provision in the contract. If you ask 10 agents, 9 are going to give you a different read on what this thing says. Although I still have not received a written reference to share with you from the Florida Realtors, there are several Florida Realtor videos on YouTube summarizing this value. And the following is a summary of an email Florida Realtors wrote to us. 3C is a total of the concessions sellers agreed to pay in Section 8. I'm sorry, Section 10. That's the total of the concessions they agreed to pay in Section 10. So if they agreed to pay a buyer's agent 3%, that's the written number, 3%. 3 times $300,000 purchase price is $9,000. That's what would go in 3C.
highlight 3C. So this is the purchase agreement, 3C, the seller expenses right here.
Yeah, let's read it out loud. Seller will pay mortgage discount, other closing costs, or concessions not to exceed. Well, the only thing we know on the day that the listing agreement is signed is that they agreed to pay a 6 overall and a 3 to a buyer's agent. So that if it's a $300,000 sale, that would be a 9. That would be $9,000. This "and" is what a lot of agents are including in the additional terms, which is not necessary. And any other expenses seller agrees to pay in connection with the transaction. So that would be things like inspections, defects, closing costs, items paid by the seller at the last minute, items paid. by seller at the last minute. I mean, I've talked to agents that say they go back and amend their listing agreements when things change in the transaction. I've talked to agents that say they add settlement statements to the listing agreement. They put language in the additional terms regarding closing costs, and they list references to including but not limited to the fees in the proposed settlement statement. According to the Florida Association of Realtors, that's not necessary. You just have to pin what you know in the blank, and the and following the blank captures all those other things. Does that make sense, you guys? If it doesn't make sense to anybody, please speak up.
Makes sense.
Wendy, go ahead.
Hold on, sorry. So I did have somebody challenge me on that the other day. I had a seller that said it specifically states, let me just zoom in so I can see it, other closing costs. And she said, in Palm Beach County, I'm picking the title company.
Right.
So does that mean that includes those fees? And I said, no, it doesn't. And she said, it says other closing costs. And we went back and forth. So I put to be determined, because we could not come to an agreement on what that meant. So
I'm hoping they amend this provision.
so I
If
just,
Wendy thinks she's alone, I've got 30 texts from agents after talking about this on the last show, asking exactly, discussing just the things she's discussing, the problems she's had. And I'm going to write to the Florida Association of Realtors asking for them to refine this. But the way they explained it to me, think of it like an addition problem. You know the first number, and that's the number you put in the blank. That's the concession that they agreed to in paragraph 10. And the and leaves the rest of it open to be added to as the transaction evolves. Does that make sense? All right. More NAR rule changes are likely coming, but we can take action now, today, The reality is we have more forms than we need. I think everybody would agree. And some of the forms we've been provided have more elections than we may need. I think everybody can agree with that. We just went over one of them. That's the 10A, 10B thing. And the fact that brokerages are doubling down and telling their brokers like completely different explanations tells you that there's confusion in the forms. But I do like what the EXP and the real agents are being told about B. It takes the selling agent completely out of the transaction on compensation. The Florida Realtors are not sure where this went, so they are covering all the bases. It's up to the brokerages to decide how they want to work. Period. End of story. For right now, brokerages have to use their critical thinking skills and decide what they want to do. Look at the bottom of every single form that the Florida Association of Realtors has published since this thing started. Has everybody seen this? I pointed it out before on the show. I just want to make sure we're all on the same page. Florida Realtors makes no representations as to the legal validity or adequacy of any provision of this form.
I mean, it's
You
incredible.
guys have to be critical thinkers. I've heard pundits for brokerages glossing over this statement like it was just a typical statement that would be made in the course of normal transactions. That's not a normal statement. That's a huge, we don't know where this thing is headed and we don't want to take a
What's
position.
$1,500? What are you talking about?
I'm gonna mute you, Patricia, I'm sorry. August 23rd, 2024, the Department of Justice sues the rental property software RealPage. Attorney General Merrick Garland claims RealPage uses a pricing algorithm and confidential, competitively sensitive information to illegally boost rent prices. They provide a platform that makes the data available to the parties to know what's going on in transactions. Where will the madness end? I'm telling you guys, I hate to sound so dramatic, but this is crazy. Michigan realtors are suing NAR over tying agreements. Sitzer plaintiff's attorney, Michael Ketchmark, yuck, sorry, did I say that out loud? Has stated in multiple interviews he's watching and will take swift legal action. He believes some of the revised forms already violate law. This is not a show that we motivate by fear. This is a show that we motivate by knowledge, power, and strength. And I stress to you guys to be critical thinkers. All right, I want to wind this up. Tales from the street, agent opportunities and misconceptions we're seeing. You guys probably know more about this topic than me. This is what I've learned lately. Opportunities, the effect of buyer commissions and lending. Some articles I've read and discussions I've heard. The VA has instituted a moratorium August 10th, allowing buyers to pay agent commissions. If you guys know more about this, please chime in. Sellers' concessions that are applied to buyer commissions will not be counted as seller contributions for the purpose of lending, but agents have to make sure their lenders understand the concessions are going in the pocket of the buyer's agent.
Yeah.
Is anybody familiar with this? This is something I learned yesterday listening to
Well,
another attorney, another brokerage attorney.
so I've actually heard of lenders now requesting the BBA when the buyers are doing their application to see, if the buyers, qualify in the event that they have to pay the buyer's broker's commission.
I think that's I mean, this is the danger of doing live shows, but talking from the balls of my feet, I think that's not a problematic thing, and I can only see the benefit. Showing the lender the BBA, because you're going to have the discussion hopefully later where the agent is telling the lender this isn't a problem because this seller concession is going in my pocket and it shouldn't be counted against borrower on the lending. Is everybody following me? I mean, I got to say to you, the lender dynamics is not 110% my solid ground, but I can understand what's going on here enough to understand that agents have to be ready to be vocal on seller concessions and the fact that that money is going into buyer's agent's pocket, not going into buyer's pocket. And so it shouldn't be counted against buyer in the lending discussion and the lending underwriting.
Well, in the additional terms that you laid out when making an offer as a buyer's agent, that the seller side to pay buyer's agent 3%.
There you go.
I mean, you're protected right there, right? It wouldn't even be at all on the buyer side. It would be totally on the seller side.
There is a collateral benefit that I had not contemplated in putting information like that in additional terms, paragraph 20 of the contract.
I mean, that's one of the most, powerful takeaways, I think, from, this whole webinar is that, Jim, if you're working with buyers, I mean, it gets the lender out of the equation. It gets everything out of the equation.
Does everybody know what Brian means by taking them out of the equation? Like the exposure piece.
Yep.
The liability piece. This is buyer's position. Buyer has signed a document saying this is the transaction I want. Provided the buyer's agent hasn't said anything incurring liability to them prior to signing the agreement that isn't supported by law or fact, then everybody should be sanitized moving forward. Common misunderstandings. Pre-offer selling agents and buyer's agents have to share their listing agreements and BBAs with the agent on the other side. I have found no rule or law saying that there is a duty to share your client's agreements. I hear it from brokerages. I've watched it in videos. I've read about it in memos from brokerages. I do not see anything that says you have to share your BBA or your listing agreement or your anything with the other side. Buyer's agents must include with their offer the showing agreements or BBA. I've seen this done and I've heard brokers telling their agents to do this, but I find no rule requiring it. It's a similar thing, but we're saying with the offer, there's no rule or anything I can say that says you have to show. I just saw a contract the other day and it had the showing agreement included with the contract offer. There's no rule that I can find compelling that. And all it does is muddy the water. I would not do it. Contracts can't contain buyer's commissions offer. I had an agent call me yesterday. I did a show for a small brokerage. I've had conversations with agents up in Treasure Coast. They're all telling me you can't put compensation offers in the contract. Tell me where that appears. I see no rule against that anywhere, and I don't know where that's coming from. Are there any comments on that showing up in the chat, Ryan? No.
Nope.
If buyer's agent comp is in the contract, agents will get paid. That is not true. This is the polar opposite of agents saying you can't put buyer's comp in the contract, but agents are telling me it's in the contract, I'm going to get paid. That's not true. You have to remember the rule of privity. Privity is the rule that says if you're not a party to the contract, you're not obligated or bound. Are agents a party to the contract? Lock down your pay in a compensation agreement. Parties can change the contract terms without the agent's consent. Last minute, right before closing. I had one Friday, a couple Fridays ago. Everybody's sitting around the closing table at the end of the day, and the agent and the parties nixed an agent out of their commissions, and they, it was terrible. Get the compensation form signed.
In addition to the additional terms, get the compensation agreement signed.
Yeah. Say you're an agent and you didn't do the compensation agreement with your offer, like we discussed earlier in the show. Get your compensation agreement signed anytime. Force the issue. It's uncomfortable, but force it. Lock in the devil you know as early as you know, the better you know. Don't wait till the last minute. Title agents will take care of figuring out commissions. Not true. I have agents telling me all the time, the title agent will figure it out. Don't send us your BBAs. Don't send us your showing agreements. Don't send us your listing agreements. If you have questions, you can provide it to me personally. Text me and I'll walk you through the solution. But in general, you're using a title agent. They're not going to figure out the commission splits and the obligations. That's not their job. Title agents require DAs, distribution authorities from brokers before we can pay people. We had a dispute the other day where the agent signed something the broker didn't authorize, and it's a big mess. DAs come from the broker. No one will ever enforce all these rules. Not true. Agents are already getting fined. I've heard about no one in Florida, but it's already happening in other states. I've heard about other agents firsthand, in podcasts, in writing, getting fined. The rules in place now are the rules forever. False. These are not the rules forever. These are a unique settlement, totally unprecedented. August 17th was a date the industry agreed upon to implement new rules. The judge does not rule on the final settlement for a couple more months. Discussions in the street, EXP and Real would like sellers to not offer preemptive buyer's comp, period. They would like to take the whole concessions thing out. I've heard high-level discussions, and they would like to just have all the offers, just like a commercial transaction. Many brokers are talking about eliminating seller agent to buyer agent compensation altogether. This would be a 10B election with the additional terms message I gave above. The Department of Justice is still watching this. Catchmark is watching this. This makes it completely, everybody know what I mean by Catchmark. He's the plaintiff's attorney in Sitzer NAR, the first lawsuit. This makes it completely on the parties. There could be no claims against the agents. I like that. Ultimately, I think this is where the industry is going. If I were to weigh in and to go further out on a limb, I would say to you, ultimately, this is where the industry will end up when Florida Association of Realtors gets the nerve, the backbone, the determination. I think this is where we'll see all our forms headed. Some Florida pundits say Florida forms reform wasn't enough. Look at the bottom of your FAR form that we went over earlier. And many brokers are already following this pattern. So many boutique agencies are telling their agents to use the 10B election, not make compensation paid from sellers agents to buyers agents. All signs point to more unrepresented buyers. The 10B scenario I described above is a good one for the parties and agents, and to not have future exposure to attorneys and regulators. So we talked about it before, there are attorneys who are doing personal injury as a function of tort reform. They have more time than they know what to do with, and they're looking for other places to sue, and they're going to try to get into broker pockets of real estate agents, and that's just a fact. I'm going to go out on a limb even further. I think our associations are watching their own liability and bottom line. I said it in 2019. If we had used today's mandatory language then, when the DOJ started hammering NAR, we may not be facing what we are today. What do I mean by the mandatory language? Everybody knows, I think. We're talking about compensation. Broker commissions are not set by law and are fully negotiable. I had gone out on a limb in 2019 and suggested agents start saying stuff like that in their listing agreements. It wasn't well received. And this is by no means, and I told you so, I'm just saying that if we take some preemptive steps in eliminating compensation coming from selling agents to buying agents directly, I think that can be another potential problem we don't have to deal with. Today, more than ever, agents have to be critical thinkers, look out for ourselves, and not follow the crowd. In my opinion, a seller to buyer's agent mode minimizes selling agents' potential future exposure. That's all I got. It's 11:07. We covered a ton. Your hair is, I can see everybody's hair is blown back. They look like they've been drinking from a fire hose for the last 67 minutes. I'm sorry.
No, Jim, that was great. I mean, there's just a couple of awesome nuggets in there that are, that we can all use to make sure, we all work hard as agents, right? I mean, the public doesn't realize, we're out there doing, meeting these buyers and sellers for dinner, meeting their family out at the pool, taking out to the golf. We're spending a lot of time and effort, to get these clients, and we want to make sure we get paid, right? And that's, and at the end of the day, that's, why we're here today, right? To make our life easier and make sure that our effort and time that we are putting in, that we get rewarded for that. So
I can't agree more, Ryan. And I want to add one more thing to that. I'm not somebody who governs by fear, not that I govern anything but my own actions, but we do have to be cognizant of the fact that these are not engraved in stone rules. This is a fluid for the next year, moving target. I can't even believe the Department of Justice is suing RealPage for software that gives everybody access to the data. I'm sorry, mind blown. Where does this thing end? There's agents that are giving virtual tours, and they're putting cookies on the counter of the property, and they're saying the seller is going to give 3 cookies to the buyer's agent. They're getting fined. Period. End of story. They're getting fines. We just have to be smart. And I think that we can all help each other. You guys can certainly help me. The texting and the information that you guys provide and the issues that you run into helps me help you. Sorry, I won't preach anymore.
awesome. Thanks, Jim.
So
Great.
I do want to give a plug for RealTrade. RealTrade is one of those platforms that you guys can use to advertise compensation to buyers agents lawfully, not get in trouble, efficiently, fluidly, agilely. I like it. And it's also the best place to maximize your opportunity for the double dip and do off-market properties and all those good things.
Yep. Yeah, to everybody, check out RealTrade. It's free for agents. We have thousands of buyers and sellers on there that can contact you directly after your listings. Cool thing is you can network with other agents, offer, like Jim said, the buyer's commission, and of course, network with awesome service providers like Jim. and we got some other new service providers coming on there as well. I do want to give a big shout out though to Jim for hosting this and going on a limb, Jim. I mean, this is, like you said, information you can't get anywhere else, and real estate attorney's perspective. And let me tell you something. Jim has awesome, his title shop, New Path Title is one of the best. They have this closing software called Title Leap. It's like a free contract coordinator. When I'm representing a buyer and I didn't get to choose title, it's tough to go through their whole software process that they have, because let me tell you, Title Leap's one of the best. Jim is available 24/7, obviously, for any kind of questions that you have. Even if he's not doing your closing, he'll answer your questions. He gets questions from agents, including myself, all the time. Like I said, I've been an agent for over 20 years. So Title Leap's awesome. And then his big free service that he does to agents, which you can connect with on Real Trade, is Title Advance, which is like there's no surprises anymore going into closing. If you're representing a seller or even representing a buyer and there's some kind of crazy title issue that pops up that delays closing, that creates a cascade of events, you now know ahead of it. You can cut it off at the pass and actually get those title issues remedied, and they're free. Guys, he's offering that free to agents. You could go to titleadvance.io, as Jim has it right up there on the screen.
Thanks, Ryan. I appreciate that. We work hard, you guys. We all work hard. We work hard to serve you, and you guys work hard to provide files to us. And so it's symbiotic, and I want to do my part, and I want to step up, because I think now is a real opportunity to get all on the same page and operate more efficiently in this. The Oriental symbol for chaos and opportunity is supposed to be the same symbol. I think there is opportunity here. I'm not going to gloss over it. Like I hear a lot of people on videos saying, oh, this is a real opportunity for you. Yeah, some agents are going to shake out, but the agents that remain, we have to know, we have to be on the same page, and we all have to be singing from the same choir sheet. And that's my role. It's my self-proclaimed role to help us all get there. All right, that's all I got.
Awesome. Thank you, Jim. Thank you, everybody, for attending. Let's get out there. Let's make some sales. We're going to get through this. It's all going to work out in the end. Good luck out there. All right. Thanks, everybody.